After 2 weeks, 12 witnesses, more than 30 hours of testimony, the public hearings into the impeachment of President Trump appear to be over. So what did we learn? The evidence established a series of facts. That President Trump launched a campaign to convince Ukraine to announce investigations into Joe Biden and the Democrats. That he withheld military aid and a White House meeting during that campaign. And that Trump's key national security players all knew about it. Ambassador Gordon Sondland put it starkly. Everyone was in the loop.
And that includes Secretary Pompeo, right?
Many people.
And, well, Secretary Pompeo?
Yes.
And Acting Chief of Staff Mulvaney?
Yes.
Shadow diplomacy outside normal channels.
He was being involved in a domestic political errand.
And so much still in the shadows. Central figures refusing to testify. Secretary of State Mike Pompeo, former National Security Advisor John Bolton, Acting Chief of Staff Mick Mulvaney, and Trump's personal attorney Rudy Giuliani.
You understood that Mr. Giuliani spoke for the president, correct?
That's correct.
As the hearings came to a close, the partisan divide wide as ever. Republicans firm in defense of Trump.
I've not heard evidence proving the president committed bribery or extortion.
Democrats emphatic. The president deserves impeachment.
In my view, there is nothing more dangerous than an unethical president who believes they are above the law. In the words of my great colleague, we are better than that. Adjourned.
So let's dig into where things stand and what comes next with our panel of impeachment experts. Melissa Murray, professor of constitutional law at New York University. Our chief legal analyst, Dan Abrams. Barbara Comstock, former Republican member of Congress who served as chief counsel for the House Government Reform Committee during President Clinton's impeachment. And Kate Shaw, who served as legal counsel in the Obama White House, now professor of constitutional law at Cardozo Law School. Welcome to all of you. And Dan, let me begin with you. Let's just start out very plainly. Did the Democrats make their case? Did they prove an impeachable offense?
Well, look, it depends what their case is, right? Did they show that there was a quid pro quo, that aid was being withheld in exchange for an investigation? Yeah, they've got those facts on the table. I think it's very hard to dispute that. But that's only the first question. Question two is, was it wrong? I think that they did a pretty good job of demonstrating that that was wrong.
And most Americans believe that now.
That he did that. But question three is the most important one, which is anything is impeachable, right? The question is this enough to remove him from office? And that's still yet to be seen. And I think one of the important questions moving forward when the Democrats think about these articles of impeachment is going to be, how broad do they go? Up to this point, we've talked about, well, they probably want to go narrow, they want to stay focused, et cetera. Now you have to wonder, are they going to go a little bit broader when they actually write up these articles of impeachment? Are they going to include some of the information about Mueller, for example, in obstruction? Because as a legal matter, you'd say, well, yeah, of course, why not include additional charges if you believe that they're valid? But as a political matter, they're going to have to decide, does that help or hurt?
And so much of it is politics. Barbara, did they make the case?
Well, yes, as Dan says, it depends on what the case is. On obstruction, I think they had a lot of witnesses who pointed out, like Sondland, that they didn't have access to the documents. They've been repeating that over. But the bribery, given that's an intent crime, that is going to be more difficult. I do think if they bring in the other Mueller things, that's going to add to the political argument of you've just been trying to impeach the president for anything. So I think it's very much like the Clinton impeachment, where a lot of people are going to say this was wrong. As Will Hurd said, it was inappropriate, the conversation, but I don't think it's impeachable. I think that's kind of where most of the Republicans are just saying, no, it's not wrong, nothing wrong with the call. The president is kind of driving that line. But I do think you're going to see other Republicans kind of take the line that Will Hurd did, sort of the Clinton line of it's wrong, but let's not impeach over it.
And one of the arguments you hear from some Democrats is even if the outcome is foreordained in the Senate, you have to go forward with impeachment as a deterrent to this kind of action from future presidents.
I think that's a very strong argument for the Democrats. The idea here that we cannot have a chief executive who believes that he or she is above the law, and a strong Congress that's willing to deploy impeachment is a huge deterrent to that. But again, Barbara's exactly right. This is not just a legal proceeding, it's a political proceeding. And the way this has played out has really been like a Rorschach test of whether you are a Democrat or a Republican, or whether you're convincible and in that soft middle.
In fact, at least in the House, those lines seem to harden over the 2 weeks.
Yeah, that's right. I mean, I do think that one defense you could imagine is the one Barbara described. This was wrong. this should not be done. Maybe it even warrants something like censure, but it doesn't justify the first removal of an American president, right, in our history. It's not quite serious enough. But you have basically seen the opposite, right? The president insisting he did nothing wrong and his party sort of coalescing around that. As you said, a little bit inconsistent with sort of public opinion. Most people think this was wrong, but of course, wrong is not the constitutional standard. High crimes and misdemeanors, bribery, they've always been understood as involving conduct that is some kind of existential threat to the political order, right? That it would be intolerable to retain in office a president who engages in conduct like this. And in some ways, that's why I think the Democrats made or the witnesses, I should say, made a case that there was a political, the investigations that the president wanted were political. The president was willing to use the White House meeting and the military aid as leverage. But there are some open questions about the military aid, sort of how and when, and specifically sort of through what channels the directive to hold the aid was issued, and then the lifting of the hold. And that seems important.
And that's when you get into the double bind, because the person who can answer the questions of how the military aid was withheld, when it was withheld, why it was held, Mick Mulvaney, the White House chief of staff, who's already publicly said it was withheld in part because of these investigations.
And that's what's going to be interesting about the Senate trial. Is it possible that any of these people would be forced to testify in a Senate trial? I don't think so. I don't see exactly how they go about doing that. But you can count on the fact that the Democrats are going to try, if there are going to be witnesses. Remember, in the Clinton trial, for example, there were no live witnesses who testified. It was arguments. And that's going to be the question here as we talk about a Senate trial. Will there be witnesses who testify?
And will you have one of the witnesses, Rudy Giuliani, actually being one of the president's attorneys?
Yeah.
And that's I
can't imagine they're going to have him arguing the case. But
well, he was on TV
on TV right now.
Yeah.
And you say you can't imagine seeing these witnesses called, but some constitutional scholars have started to raise ways that this might happen. And let's start with the one argument that is made is that the House could try to compel it by setting a deadline for impeachment. That they could then go to the courts, and because they have a deadline coming into an election year, the courts could expedite any proceedings. It happened in 2000 during the recount of George W. Bush.
It's a standard feature in election law, and there was a great piece by Ned Foley, who is a professor of election law, who made this case as well. That's definitely one angle, and we've seen courts fast-tracked, and the court fast-tracked when it's had to. But again, the political optics of this, I think, are really important, and the idea that we are fast-tracking, this is a witch hunt, this is all in the bag already. I think the Democrats want to stay as far away from that line of inquiry as possible.
Well, and the problem they have, too, is one of their strongest articles of impeachment would probably be obstruction. And if they go and get the witnesses, that's going to undermine that article of impeachment. But not getting those firsthand witnesses is a problem, and you're not taking the case seriously enough, and you are making it more political.
That is precisely the dilemma, Kate, because, I mean, the Democrats are saying now it's proof of obstruction that these witnesses are not coming forward. Why not take the time to see if they would come forward, if they actually have the goods? We're already getting more documents on Secretary of State Mike Pompeo as well.
Yeah, no, I mean, I feel like they're a little bit echoes of some of the strategic calls made by Robert Mueller. Remember, he decided not to try to force the president to sit for an in-person interview, instead to say it would take too long, let's just work with the material that we have. In some ways, the Democrats seem to likely be moving in that direction. We're just going to, we have the universe of testimony, and we're not going to try to force more. But I think it's right. If there is material information that some of these witnesses still hold, there's a real question about whether they should exhaust all legal avenues to try to access it. And I think Melissa's right. Courts can move quickly if the Democrats, I think, are very focused about what they are seeking and the deadline on which they need it. There's a real chance they could get a definitive ruling. I don't think that would remove any obstruction article. I mean, I think there are other elements of the obstruction case the Democrats are building, including potentially witness intimidation. But I do think that there's an argument that they should try to run this process through a little further.
Something is happening tomorrow, Dan, that could play into this issue of obstruction and also whether broaden out the articles of impeachment. The court is expected to rule on whether Don McGann, the former White House counsel, President Trump's former White House counsel who played such a prominent role in the Mueller report, whether he should be compelled to testify. You could see him potentially then called as an impeachment witness by the House Judiciary Committee. Potentially, but that would be a court ruling. And then the question would be, where does that go from here? And you would have other witnesses say, well, I'm going to wait to see the resolution of that as it works its way through the courts. I mean, there's always a way to delay these until it gets to the Supreme Court. You can keep sort of pushing it off and saying, well, I'm waiting for a final ruling. But, to take a step back, one thing we talked about when we were talking about broadly about impeachment, about what the founders thought, et cetera, think about the standards that were set. It's high and low, right? It's misdemeanors and it's high crimes. It's bribery and it's treason. There was a reason that they put that in there. They intentionally wanted it to be kind of vague. They wanted to talk about wrongdoing,
generally. So when we talk about bribery, it doesn't necessarily have to adhere to the statute, because the statute didn't exist when bribery was put into the Constitution and talked about impeachment. And so it's going to be very interesting as these articles move forward and the word bribery is in there potentially. Are they talking about the bribery as the founders thought of it, which is just kind of payoffs, kind of improper activity, et cetera? That's what they were worried about, not the federal statute.
And they were particularly worried about improper activity involving foreign nations.
Yes.
So that, I mean, this is completely on point in this case.
Well, I think it was definitely the case that they were worried about foreign intervention in the domestic operations of the United States, and this is clearly implicated here. It's also implicated in the emoluments case, which seems like 500 billion years ago, but it's certainly relevant for this. But again, Dan is right. They didn't anticipate the federal bribery statute, 18 U.S.C. 201, but I don't think they have the opportunity to completely take that off the table in trying to understand what bribery means in the context of impeachment. They have to look at the modern model, if only to sort of understand what we're working with today.
But impeachment was always meant to be a very broad consensus and bipartisan, and that's why in a 50-50 country, you're going to get a 50-50 divide. The House will vote impeachment. The Senate, most likely at this time, unless there are additional witnesses and things change, will, acquit. And then the public will decide in November.
Kate, there is a new player that becomes involved if indeed this does go to a Senate trial, and that's Chief Justice John Roberts. There's also some question about whether he would have the power in a trial to compel new witnesses.
So if it goes to trial, which it looks almost certainly as though it will, then right. So Chief Justice Roberts will preside over the trial. And I think it's a role that he can kind of define as he sees fit. He may take the position that essentially William Rehnquist took when he presided over Clinton's impeachment trial, that it's a largely ceremonial and ministerial role, and he's not going to do a lot that substantively affects the course of the Senate trial, ordering witnesses to appear, things of that nature. I think it's more likely that he will urge the Senate, just the majority of the body, to work out those determinations internally, and maybe with guidance from Roberts, but not with Roberts making those.
Well, that could lead to an
calls.
interesting situation, Dan. Let's say, for example, the Democrats say we want to hear from Mick Mulvaney or Mike Pompeo. Roberts gives it over to the Senate majority. It's not certain that you would have a majority against seeing Mick Mulvaney come forward. You have a few senators on the fence who could vote for that.
It could, but it would be viewed as heresy within the party. I mean, you could say that maybe they'll be able to peel off a few, and that's possible. But I think we're looking at it the right way, because I think Kate's right. I think the idea that somehow Chief Justice Roberts is going to be a hero for the left in there, and he's going to force witnesses to testify, and the Senate's going to have to overturn him, I think that's a pipe dream. The reality is it's going to be based on Senate votes, and so the best they can hope for is this idea of peeling off a few of the moderates. But I don't see that happening either, because I think that they're going to want to stay out of being the focus.
Well, that's the question about staying out of it, Melissa. There's so many different moving parts to this. The Supreme Court also right now, John Roberts, considering two tax cases about the President Trump's tax returns, both the one coming out of the DA here in New York and the Congress also seeking them. And there's been some suggestion that if the Supreme Court took these cases, then he would be asked to recuse himself from a Senate trial. I see you guys shake your heads. So why don't you guys?
It's in the Constitution. They can't do that.
So, again, the court has been at great pains to kind of stay out of the political fray. They had the opportunity last term to take a lot of controversial cases. They punted on those. Now those cases are before the court in this year's docket. It's going to be a really explosive year for the court, I think. And I think Chief Justice Roberts is at great pains to keep the court out of the political fray. I think his model is, again, going to be his own justice, Chief Justice William Rehnquist, who said of his role in the Clinton impeachment, I did nothing in particular, and I did it very well.
And Katie and I have talked about this online, and we don't know. It takes 4 votes in the Supreme Court to get cert, to consider these cases. If the Supreme Court takes them, they're going to be deciding this right in the middle of the presidential campaign, probably in June. Does that sort of put a thumb on the scale towards the court saying, let's stay out of this?
Let's stay out of it. It may. It also may mean that if they do take the cases, they expedite them, even informally, so that they're decided in, February or March rather than in June. But on recusal, there has been some speculation that if the court took these cases, not that the chief could recuse from the Senate trial, but that he would have to recuse from the cases. Potentially.
The tax case is so different.
But of course, and during the Clinton impeachment, you had all kinds of executive privilege cases that were going up in that same time frame. So there's precedent for this, and it's in the Constitution that the Chief Justice has to.
Oh, he presides. I think there's no question.
No no question he's going to preside. You do have the experience, Barbara, with the Clinton impeachment investigation. And the fundamental lesson, which you guys have all echoed today, it comes down to strategy, political strategy. As you look at the Republicans in the Senate, is their strategy going to edge more towards the president's strategy, which was nothing was done wrong, or more along the lines of, yeah, perhaps it wasn't appropriate but not impeachable?
I think it may be the latter for quite a few of the senators. I also think that, the president is talking about, wanting to bring all these witnesses on the floor, Hunter Biden, things like that. I think
he also wants Adam Schiff, who will be a witness on the floor.
Exactly. I think you're going to see Mitch McConnell will keep a tight rein on this. He wants a short trial. He does not want this to be a circus. I do think the White House probably would like to have a Senate trial very much like the Corey Lewandowski hearing in front of Jerry Nadler that was such a circus. So that's kind of what they're threatening and what they would like. But I do think the reason you had, for example, Lindsey Graham come out and say he's going to do the investigation of the Hunter Biden and those matters is so that they don't have to deal with that issue on the Senate floor.
But before we go, do any of you think that it's possible that the House actually doesn't follow through and vote on impeachment?
I think it's I mean, I don't know. For the first time this morning, I started to think, boy, do they consider a censure instead? Because
I think that's more likely for the Senate.
I know. But some sort of statement.
Yeah.
But, I mean, look, it's very hard to think of how they could not move forward.
Back off at this point.
I don't think you unring this bell. I mean, this bell's going to get rung.
Okay. Thank you all very much. Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.